Lastly, we'll talk about everybody's favorite subject over the past few years, and that's civil forfeiture reform. As you know, there are parallel paths going on in the legislature. The Speaker and Chairman Willard have a work group going on now debating HB 1, which was introduced last year and did not pass, and are currently going through a perhaps second iteration. The governor has tasked this council with coming up with consensus-based ideas for civil forfeiture reform that increases transparency and accountability completely outside of the framework of HB 1. And the governor asked us to do this after some press accounts of some potentially inappropriate spending of forfeiture funds by various different officials around the state. So the Forfeiture Committee, who was Sheriff Berry, thank you for your service on that, Jackie Johnson, the District Attorney from Brunswick, and Senator Calzert, who's not here today, unfortunately, met on 3 or 4 different public meetings and certainly communicated with each other outside of this to try to reach these recommendations that would be non-controversial. And unlike some of the reentry pieces where the council works very, very closely with the legislature to draft a bill reflecting the council's recommendations, I don't believe that you'll see that in the world of civil forfeiture. I think that the governor has tasked us with delivering with him some consensus-based recommendations about improving accountability and transparency, and whether or not those enter the bill in any enter a bill in any form or fashion are up to the completely up to the General Assembly. But to meet the governor's expectation and request of us, I submit these 4 recommendations on civil forfeiture reform that I'll briefly go through that I believe now has consensus from all the different stakeholders and then can be voted on by the committee. Recommendation 1 is standardize the procedure used in all forfeiture cases. There are currently 34 different statutes, forfeiture statutes in Georgia. 14 different procedures are currently used to enforce those 34 statutes, and 3 of those statutes provide no procedure at all. Standardizing the procedure will expedite the return of property to innocent owners while also expediting the forfeiture process for property that is appropriately seized. The second recommendation, I think that as you talk to district attorneys and law enforcement around the state, is that using the law enforcement related purpose for civil forfeiture funds are absolutely vital for the protection of citizens around the state. Sometimes they're buying bulletproof vests, sometimes they're buying new cruisers. I think that you can, the law enforcement purpose is something that I don't think needs to be touched or changed whatsoever. However, especially in light of some of the reports on whether or not some expenditure decisions truly meets that law enforcement purpose, the recommendation would be the adoption of statewide rules relating to the specific expenditure of those funds within that purpose. But I also think it's important that the council doesn't go about trying to write those rules with specificity, and the profession should do it themselves. So the Forfeiture Committee's recommendations would be that the post council adopt and promulgate rules for law enforcement, while the prosecuting attorney's council will adopt and promulgate rules for prosecutors. Third recommendation would be required standardization and improvement of the state's forfeiture reporting requirements. Currently, the reporting requirements vary at different local levels. This would not have any bearing on local reporting requirements at the local level, but this would just require that all agencies submit an annual report. Quarterly is probably too onerous and burdensome, but annual reports to the Department of Audits and Accounts with specificity from the rules discussed above, and they would be required to submit those reports even if no forfeitures or expenditures are listed for a given year. And that would certainly provide tangible evidence of greater transparency and accountability. And then lastly, protect innocent owners by requiring an expedited judicial process for recovery of improperly forfeited property. Currently, some people who believe that they have had their property wrongfully seized or sometimes rejected by technicalities alone. This would give every property owner the right to petition the court to get their property back. Every person would have a claim that must be heard by a court, and the recommendation would require that judicial proceeding to occur within a reasonable time. And so those are what I believe. Sheriff, I'll defer to you as the only member of the committee present, but I believe that's where the consensus came out on the forfeiture committee, and I think that those are 4 very good recommendations that would not diminish this for the important process that it is, but would also greater protect innocent owners and increase transparency and accountability. Sheriff?
The language in 4A gives me pause. Okay. Because it implies to the reader and to the public that there is a forfeiture proceeding that takes place in Georgia where there is no judicial review. And that's not the case. Every forfeiture in Georgia that I'm aware of always gets a judicial review. Even whatever amount, whatever. I mean, every one of them go in front of a judge. So I think that the language there gives me pause. The language there gives me pause for someone to think. Now,
there's non-judicial review. There's non-judicial forfeiture.
I know that's what. See, it always goes in front of a judge. Even a judge issues an order, and there is an opportunity to be heard. I think that's one of the. Well,
why don't we? I certainly think that everybody is in agreement with the spirit of 4A, and right. So why don't we revise this language to reflect that every determination or every determination on a petition by a potentially innocent owner is judged on its merits and not on a technicality.
Thank you so much. That would be acceptable.
Does anybody want to talk more about civil forfeiture before lunch?
I have one thing I'd like to add, Tom. This is just called protecting your own turf. The very last thing, B, says require that the judicial proceeding occur within a reasonable time. And as a Superior Court judge we already have time limits on forfeiture now, which are sometimes very difficult for a Superior Court judge who plans a calendar a year in advance to say, well, you got to hear this in 30 days, and that's within.
That's why there's no number in there.
Well, I guess my thing is I would encourage the legislature, or when they're considering making these changes, that they consider whether there ought to be other classes of courts that could also hear forfeitures or divide, not that I'm trying to throw off of magistrate judges, but they're used to dealing with stuff that walks in today and they hear it tomorrow. Superior Court judges don't act that way. So at least it should be a consideration as to make it workable for the system.
And I'm completely comfortable, if it's the will of the council, to add that recommendation of, require that the judicial proceeding occur within a reasonable time, but also examine the availability of other court classes to hear forfeiture cases. Judge Teske?
No, I was just going to add, piggyback what Judge Dill said, that, and just make a note that...
Does juvenile courts want forfeiture cases?
Not really. But there is a provision in the juvenile code that carries over in 242 that allows for the Superior Court judges to designate juvenile court judges as Superior Court judges. And I've been doing that for the last 4 years. And I hear forfeiture cases as well. and also sympathize in terms of the spirit. So I'm just simply making a note that it's there, but just, but I'm not asking you. I'm just like, you may want to include other class of judges in addition to juvenile court judges.
What I would envision is, I would hope that they would say, if you want a fast hearing, here are all the people that can hear. If you want a more deliberative hearing, you can request, and, you can do that, but it may not be heard within that first 10 days or whatever the time limit may be. That's the only suggestion I have.
Representative Pack?
Thank you. One of the issues, I think this devil's in the details, and we have two competing probably bills that come out of this. One of the things I think that either bill does not address is a lot of times the amount seized tends to be small, so there's not an incentive for a lot of people to challenge and try to get that money back. I'll give you an example. I've heard of a story where someone was driving through Georgia in a way to go to the America's Mart right down the street here, and they got pulled over, and they had cash because that's what they pay the vendors with, and it was around $4,000, I guess. They got seized. The officer obviously had probable cause, I guess, to seize that money. We'll leave that for another court. But the fact of the matter is, this person lives in another state, then it puts it on you to say, well, do I hire somebody to get this money back or not? And I think we're not really addressing that issue. So if as this goes forward, I would like the council and the legislative body, and I'll make a note of this, to address this incentive for improper procedures, maybe with attorney's fees provisions and things like that, if the person in fact has to incur costs to get the money back.
Is it the will of the council to include an attorney's fees bullet under recommendation 4?
I'd be afraid to get too far in the weeds myself, but
I'm not asking the council to do that, but I'm making a note that that's probably one of the goals that we probably need to approach. Otherwise, you could have all these procedures put in place. I know in the federal system, the same problem occurs because you have a seizure and the innocent person gets notice of it, and then the question becomes, does that person have the resources to, in fact, hire somebody to challenge the forfeiture? A lot of the money gets forfeited without challenges because of that financial disincentive.
Thank you. Is there any further discussion on the forfeiture recommendations from the council?
Is there a motion we adopt the 4 recommendations as listed?
Second.
All in favor?
Aye.
Opposed?